Introduce Louis Levy.
Thank you, Chris. Very much appreciate it. Good morning, Teamsters. Good morning. Good morning, Local 396. Good morning, Joint Council 42. Thank you all. Victor, thank you for hosting us. With us from Collective Movement Builders, Rosemarie, Molina, and Claudia, Magaña. They're going to be assisting me in our presentation this morning. And this morning is about giving you all tools to represent our people and to develop cooperative systems with our employers to make sure that businesses understand that their bottom line is going to get hurt and going to get hit, and that we're here to cooperate with them, to help them, and to be able to deal with these situations in a reasonable, rational way that doesn't send everybody, number one, running for the exits, number two, doesn't shut down businesses, and number three, and most importantly, protects our members' rights. This morning we're going to be going over a few things that relate to how the National Labor Relations Act intersects with immigration law, and what we can do using our tools under the National Labor Relations Act to protect our people and to develop the relationships with employers that we should be doing to develop, most importantly, planning for the eventual raid. There's basically three buckets of things that can happen in the immigration world. And that is, number one, the I-9 audit. Number two is the actual raid. What happens if there's a raid? What do we do to respond to that in a timely manner? And number three, what do we do in the aftermath of a raid? How do we deal with that? How do we put the pieces back together? We were driving in this morning, and one of the first things on the news was apparently there was a series of raids in Pomona earlier this week at the day labor centers.
There it is. Cell phone video shows organizers with this day laborers work center here telling immigration agents they don't have a right to be on private property, and yet there they are taking 3 people into custody. Dozens more were able to run behind the gated area of the center, pointing out the private property signs, not allowing anybody to get in there. One of the men taken away, by the way, we're told was a man who had been hospitalized because he got roughed up and had just recently had stomach surgery. But this is what organizers say they're most upset about.
I need a warrant to see them out. I'm going to ask you.
It's that issue of showing a warrant. They tell us over and over they asked agents to show warrants for those arrests. Nobody would do that.
ICE is still coming after our members. And first of all, what I'd like to do is give you a very brief overview of immigration law, United States immigration law. And so in the 19th century, you have immigration laws that are basically barriers, gates for people coming from specific countries, notably Europe at this time, Eastern Europe. We have the Industrial Revolution in the late 1800s. And because of the extreme need for human capital, for workers, all of a sudden the doors get thrown open. And the country of origin quotas and barriers that were in place before, say, 1885, suddenly go away because of the need for a vast army of workers. For about 30 years, America welcomed everybody. That was the era of the Statue of Liberty, right? Give me your huddled masses and everybody else, and we're taking everybody in because we are the beacon of liberty. And then there was a backlash. And after the turn of the clock into the 20th century, the early 1900s, there was an extreme backlash against migrant immigration. And specifically immigration from the Far East, Chinese and Japanese, and also from Eastern Europe, where most of the people who were now workers in the factories that were creating the industrial base in America had come from in the first place. And so the doors get shut again, and they basically stay shut for the rest of our history up till now. From the 1920s onwards, immigration law looks at 3 things as to whether or not you're going to get into the country. Number one, again, your country of origin. Is there a quota that applies to your country of origin? Number 2, do you already have family members in the United States? immigration law gives extraordinary preference to people who already have family members in the States, and especially family members who've been here for a significant amount of time, and family members who might have a nice, profitable business. And then last but not least, immigration law also looks at special skills. This is where your H-1B visas come into play. If you have a special skill, the door might be open for you to come in to America if there's an employer that can't find an American to fill that job and needs you to come from India to code software or whatever it happens to be. So the three buckets that apply now for immigration law again are country of origin, which is usually going to have a quota applied to it, whether you have family members in the United States, and whether or not you have a special skill and the employer is requesting that you come into the country to perform that special skill for them. The one aberration in sort of that straight line from the early 1900s till today in our immigration law was the Immigration Reform Control Act of 1986. IRCA changed a couple of things that were very important in terms of not only how immigration laws are being enforced, and of course the amnesty that occurred, the amnesty window that occurred for IRCA, but also how it impacts federal labor law and how immigrants, undocumented workers, are looked at under federal labor law. Again, IRCA changes things so that, number one, you have this giant amnesty, which is, again, pretty much exhausted. Number two, for the first time, it makes it illegal under federal law for an employer to knowingly, intentionally employ an undocumented worker. And number three, sets up our E-Verify, our I-9 system for employers basically mandated to utilize that or some other system to ensure that you're hiring an individual who is entitled to work in the United States of America. So what does this all have to do with labor law? Number one, workers, whether they're undocumented or legal, are still members of our bargaining units. They're still entitled to our best representation. They're still subject to the duty of fair representation. And above and beyond that, I think we have a moral responsibility to represent these people. And a moral responsibility, hopefully, to bring this country out of the dark days that we're in right now. So immigration intersects with National Labor Relations Act in a number of ways. Number one, Section 7 of the National Labor Relations Act makes it unlawful for an employer to interfere with protected concerted activity, PCA. When employees discuss and advance issues concerning their terms and conditions of employment about immigration issues, that's protected concerted activity. So the National Labor Relations Act, of course, governs our relationships with employers. It governs protected concerted activity. And the National Labor Relations Act, in both protecting the individual right to engage in protected concerted activity, gives unions, through that protected concerted activity, the right to bargain over immigration issues. These are all issues that impact terms and conditions of employment, right? If you're going to get yanked off the job and thrown into a jail, you're going to lose your job, right? That affects your terms and conditions of employment. If you're scared to death every day that ICE is going to come through the door and take you away, that affects your terms and conditions of employment. You're not concentrating on doing your work. You're nervous. You're upset. I'm upset. I'm nervous. We've got the right and the power and the ability to put ourselves into and protect as best we can through the bargaining process all employees in the workplace, including, of course, the undocumented workers. And so we can protect people primarily three ways. Number one, of course, by using our contracts and grievance procedure. For example, if employees are separated from employment because of an ICE raid, they're terminated. Is there just cause in that situation? We have our disciplinary grievance process to utilize to help protect people in those situations. If the employer promulgates perhaps an unreasonable rule about the employer cooperating with ICE and providing additional information to ICE about its employees, that may be something that violates the collective bargaining agreement in terms of a reasonable rule that we can grieve and go after. Ability to grieve, employer actions, and sort of the range of employer actions that relate to immigration that we could grieve is really only limited by our imagination. Pretty much everything relates to terms and conditions of employment, and with a little creativity, we can hook that into somebody's immigration status. You lose your health care because you had to go away for 30 days to take care of your immigration status and you were off payroll, other things like that. That's the one bucket, using our grievance process to protect our workers. By the way, if anybody has any questions at any time, please raise your hands.
Yeah,
Hey.
so the grievance, who am I filing a grievance against if ICE comes in and does this sort of thing? Who am I filing the grievance against? The company?
Yes, you're filing the grievance against the company because they have discharged your employee, they removed him from the payroll, they took him off of the healthcare rules, whatever action they've taken in response to a potential detainment of the employee, that's what we're going to grieve.
Okay.
The second area is effects bargaining and bargaining demands over how an employer basically deals with response to ICE, things that can be done at the workplace to lessen the anxiety of workers with respect to the potentiality of ICE raids, and to create a collaborative relationship between the employer and the union. And again, we'll get into this in much more detail later on, but we can bargain over such things as I-9 process. How does the employer use the I-9 process, the E-Verify process? If there is ever an I-9 audit, how does the employer respond to that I-9 audit? Is the union going to be involved in that? Is the union going to get notice of that? So creating structures for cooperative relationships in terms of notice and support in the event that ICE comes to the workplace. These are green cards, right? They're also called red cards. Know your rights. These are immigration rights. Just like we have our Weingarten cards, folks ought to have their green cards to know their rights with respect to interacting with a federal officer and representative of the Immigration Control Enforcement Agency. These are really important. Like the green cards are super important. Yes, we should have a database. We're going to have templates that I have put together that you can use for effects bargaining in the 3 different categories that we're going to talk about later on. So number 1, we have the effects bargaining process so that we can bargain with the employer about, again, making the workplace, I wouldn't say safe from ICE, but a workplace where people are not, they don't have anxieties about a raid coming in. They know the employer has a process to deal with ICE if there is a raid. The other really important buckets, of course, is how the employer and what employer plans are in place for the aftermath of the raid. This is really sort of the most important part and the most important piece of the situation, because at that point, you definitely have people who are in jeopardy. You have people who are potentially on the imminent cusp of being flown out of the country to who knows where. If an individual is identified and placed into essentially the rapid deportation procedures, that is something that the family of that individual is going to want to know right away in order to be able to get them representation and hopefully hold off the deportation.
I'm going back to this grievance. So the company will play the card that he's abandoning his position, right?
Sure. And yeah, I mean, obviously it's an issue that that we have to come up with a creative response to. I think the creative response is the reason that the person's not here is because you had an arbitrary raid by ICE, and you should do the right thing and hold this person. You know, if this person comes back and is able to, essentially salvage and rectify their work situation, so they can show you they're allowed to work, you should reinstate them.
Okay. Okay.
That's where I'm going with this. Because yes, I mean, obviously, if someone's arrested and they can't appear for work, our usual problem is, yeah, they've abandoned their job. But I think in this situation, there are special considerations, again, because these people do have the opportunity, potentially, to cure any problems they've got with their work status. Okay. And if they can do that, they should be reinstated. And they should be reinstated, made whole, et cetera, et cetera. So that's my position there. So all of you in the public sector, and I did not mean to exclude you in any way, shape, or form, because I do a ton of public sector work as well. But all these rules apply to the public sector as well. The question is there exposure if the union essentially sort of maybe interferes with the verification process or gives false information in the verification process? The answer would be yes. So, very, very basic principle in terms of federal law and ICE agents. Any interference can be a federal crime. This again becomes very important when we're dealing with employers who want to work with us, because those employers also need to know that if they take active steps to try to maybe hide their employees if there's a raid, that is essentially harboring an illegal alien, and that is potentially a felony under federal law. Ma'am.
you have any type of template or document that we can notify an employer if that employee is picked up at work? So the employer has knowledge that we can serve them to say, you know why the employee hasn't come back to work, and we can get in front of it that way?
I don't have something specific like that in the paperwork, but I have something that touches on that, and that you could probably use to get to that next step that you're looking for, which is the notice to the employer that somebody has been removed because of an ICE action.
I'd like to remove all the bullshit in between about, oh, they have no idea that somebody got picked up and they didn't come to work.
Mm-hmm.
They have knowledge of it if they're picked up at work.
Yeah, absolutely, no question. And then, look, I mean, that's constructive actual knowledge. You can't deny that. Negotiating with the employer, bargaining with the employer about, again, establishing a jointly agreed to plan to deal with the eventuality of an ICE rate, and what the employer's responsibilities are, what the union's responsibilities are, things of that nature. And yeah, there should be something in that context where someone is notifying the family of a worker who might have been taken by ICE, and also in advance of that ever happening, having a training session with the employees, having a plan in place. This is what we do in the event ICE knocks on the door. And we'll get into some very specific things that are going to be very important about setting up these plans in terms of where ICE can legally go and where they can't legally go. What are the public spaces at the workplace where ICE can go without a warrant? And what are the private areas where ICE cannot go without a warrant? That's going to be really important. Again, assuming that we still have a Fourth Amendment, if you have a door that says public not allowed beyond this point, that literally is a barrier to ICE. They have to have a warrant to go behind that door. And so these are some of the things we're going to talk about in terms of planning and educating employers about how they can protect their property and themselves. As Jenny just said, there are websites where you can go to, government-run websites, where you can track people who've been detained. That information is going to be important in the aftermath of a raid, potentially, if you've had people who've been detained. So again, another item that we're going to want to put in the bucket of things that we're going to be bargaining with about the employer to deal with raids, right? Okay, so just kind of to wrap this section up. So effects bargaining, and just some of the sample bargaining proposals that we can have and that you'll see later on. Paid leave, if somebody has to take care of getting their immigration status repaired, getting work authorization. Continuation of health insurance. I think that's super important while people are on leave. Retention of seniority. Somebody comes back, their seniority should snap back. Rehire rights. If there's no seniority's brokered or whatever, maybe these folks who come back after a year, 18 months or something, still have preferential rehire rights. Discharges due to immigration status are subject to grievance and arbitration where there's questions about the person's actual immigration status, and they may potentially, shouldn't have been turned over to the employer, to ICE by the employer. So just a very small sample, the types of proposals that we can make in effects bargaining. We try to deal with the immigration issues that unfortunately we're going to have to deal with. Before we get into info requests and grievances, somebody brought up the idea or the issue about, well, there's a lot of bad employers out there, and bad employers probably would have no problem calling ICE on their own employees, right? We know that's happened. In fact, back in the day, right around when IRCA was passed, that was like the go-to card for a lot of employers when we tried to organize them. As soon as the union showed up, if they had an immigrant-heavy workforce, they'd call back then. God, it wasn't ICE. Who was it back then? Whatever they were back then. Basically, have everybody hauled off and deported. Now, is that an unfair labor practice, you think? Yes? Who says yes? Yes. Who says no? All right, the yeses have it. In fact, in a 1984 decision by the U.S. Supreme Court on a case called Shurtan, that's Suretan, like you're surely tan, baby. Shurtan versus National Labor Relations Board, the Supreme Court, the then Supreme Court, not this Supreme Court, but that Supreme Court, where an employer calls immigration to get rid of its employees for the express purpose of undermining a union organizing drive, or in retaliation for the employees' exercise of their Section 7 rights, that is in fact an unfair labor practice. and the employer can be found in violation of the National Labor Relations Act for doing that. Awesome, right? We got tools. We can go to the board and we can smack an employer with an unfair labor practice, right? Hopefully. Exactly, hopefully. There was a second Supreme Court decision called Hoffman Plastics. And Hoffman Plastics, basically the issue was, can the NLRB order an employer to rehire an undocumented worker and give them back pay for the period of time they were out of work?
Yes.
No. No. So in Hoffman Plastics, the Supreme Court said, well, Congress just passed this thing called IRCA. And IRCA says that in order to, that employers cannot intentionally employ workers who are not allowed to be here. And if you're not allowed to be here, that means you're not supposed to be making money. And if you're not supposed to be making money here and you can't work here, that means the government can't order an employer to rehire somebody who legally can't be here in the first place. So in Hoffman, sorry, go ahead, sir.
Would they be liable, though, for wages that are owed to that employee still?
Sure. So at least in California, we know that. California, Section 203 of the Labor Code still applies. So any wages that that person is owed at the time of separation, they got to pay it, and late penalties would apply. And that's something else we'll talk about as a tool that we could use in place of going to the NLRB because of the Hoffman Plastics decision. So in Hoffman Plastics, although it's an unfair labor practice for an employer to retaliate against undocumented workers for attempting to organize and exercise their protected concerted activity rights, there's no remedy essentially, because they can't be reinstated, because reinstating a person who can't legally work here is in and of itself illegal. Unfortunately, the National Labor Relations Board route kind of, and really is not very effective because we don't have the ability to put a ton of economic pressure or liability on the employer through that process. So as Robert said, and Robert pointed out, one of the tools that we're going to talk about and potentially use in this situation is our late wage filings with the Department of Labor Standard Enforcement to get penalties for these people, which in some cases might even be more than the back wages they're owed, right? So we do have that remedy available to us that is not available through the National Labor Relations Board. Okay, so let's talk about information requests. Let me just segue real quick for public sector folks. Although there has not been a decision through PERB or the California Supreme Court on the same issues as Shurtan or Hoffman Plastics, I think it comes out the same way. If an employee, if a person cannot legally be employed by an employer, I think the result always is a court cannot legally force the employer to do something that in and of itself is illegal. So I think the same result happens in the public sector. First of all, we have a powerful tool in our right for information. Our right for information, both in the public sector and the private sector, is pretty broad. I mean, it's not like, in court where we have to show specific relevance and it's admissible and all that type of shit. If it is just barely relevant to allow us to help represent our people, we're entitled to it. And unless it's like some kind of trade secret or financial information, we're still entitled to it. In the public sector, we get that anyway because that's all public record, right? So we have a really super powerful tool in our right for information. Obviously, the right extends to terms and conditions of employment, private sector, the public sector, scope of representation. And again, because immigration work status, verification processes, they're terms and conditions of employment. Like you said, if they come up, they do a review of their employment records and they come up with a no match, well, that person is probably going to lose their job. That's a term and condition of employment. We get to ask information about that. How did you find out about this person? Was this a random thing? Did you plan to do this? Did somebody tell you that there might be an issue with this guy or gal? We have the right to ask for very specific information about individuals like that, in addition to very broad information requests. What are your plans? Do you have any plans? Have you ever been raided before? What happened? What was your reaction? We're entitled to all that information. They got to give that to us. Information requests, of course, both private and public sector, don't have to be limited to the main table in bargaining. We're entitled to ask for information during the life of the contract to be able to enforce the contract and to be able to properly represent the bargaining unit. And of course, information requests also are always connected with our individual grievances to find out more specific information about those grievances, like in the situation where we have a bad I-9 match and they fire the guy for cause or the gal for cause because they lied on their application that they were documented to work in and had permission to work in the United States. Well, we're going to ask again for how did you find out? What tipped you off? Was this a random audit? Was this a regular audit? Did somebody tell you that they had suspicions about this person? So again, we're going to use our rights, the tools that we do have, to dig down and get information that's going to allow us to both represent the individual who might be affected and the entire group. Sort of the last bucket in this area really are tools of enforcement. Because, unfortunately, the NLRB doesn't have a lot of heft in the area specifically of where we have folks who are terminated as a result of immigration issues and the inability to award back pay. We want to rely much more heavily on our grievance and arbitration systems to try to rectify, deal with the employer, as opposed to going to the National Labor Relations Board. Not only can we use the present language in our collective bargaining agreements to protect people through grievances where appropriate, but also if your contract is coming up and you're renegotiating your contract, think about creative language that you could put into your contract that might deal with and preempt other issues coming up in the future with respect to immigration. So language that covers, again, giving employees leave to deal with their immigration status, to be able to get their paperwork in order. Contract language that requires the employer to notify the union of any contact by the federal government with respect to immigration status for any employee, any bargaining employee. So again, be creative. You have the right to bargain these issues. We have the full right to, again, be creative and come up with ideas that go into our collective bargaining agreements that, hopefully, for a very significant amount of time, as long as that collective bargaining agreement is alive, is in place to protect the rights of the bargaining unit and make sure that nobody is subject to arbitrary and totally irrational treatment simply because of their origin, what they look like, or how they talk. That's what we want to prevent, and that's what we want to protect against. Claudia and Rosemarie.
Yes. All right, we like to walk and talk. Hi everyone, how are you doing? Are you learning something? Yes. All right, we hope to teach you some more. Sure.
Hey everybody, good morning. My name is Claudia Magaña and I'm with the Movement Builders Collective. I'm really grateful and glad that Joint Council is holding this space to share this really important information.
And I'm Rosemarie Molina. You can call me Rose. I'm also with the Movement Builders Collective. We work with this local for many, many years. And I also teach labor studies at UCLA. So you're going to get some of my professor lecture today. So before we get started, I do want to share with everybody that even though Claudia and I have been organizing for the last 15 years, we've done a ton of external campaigns, we've worked a lot with immigrant populations, we're not attorneys. And so what we're sharing with you is for educational purposes only. If you have very specific questions about something happening at your workplace or something happening with your workforce, that's what Lewis and Harrison are for, right? They're your counsel to ask those types of questions, but we can answer general questions. All right, so let's get into today what we're doing.
Yeah, so, you already have a lot of detail that's going to be shared, already was shared about what you all can do as representatives for your members. This training is going to be a little bit more basic. It's almost, think of it as a train-the-trainer. We want to equip you with the tools for how to interface with your members. What are the basic rights that you need to know that you can communicate to them so that you're best prepared, they're best prepared, you understand what's happening. I think we're all seeing what's going on, so we want to be really clear about the context that even though we all have rights, they're clearly being violated every day. People in our communities have had their rights violated since the beginning of these rights existing, right? So we know it's not new, but we're seeing it really aggressively right now, and so let's exist and be real about the context that we're in. That being said, we still need to really know our rights, and more important than ever, need to be enforcing and holding those rights, to these powers that be. And then, just given what's happening, there's absolutely no excuse in this time for folks who are at risk to not start preparing for the possibility of being detained or having someone in their family be taken, right? And so we'll talk about what it looks like to start preparing for that possibility. There's a lot lost in not preparing and a lot gained in preparing.
All right, so we're gonna ground ourselves in the moment that we're in right now. So just for my own knowledge, how many of you have workplaces where you have immigrant workers? Or people have families who are immigrant workers? All right, so almost all of us in this room right now. So this is information that can touch us. What's happening right now are what are considered repatriation drives. This isn't the first time in history that it's happened in a way that's based on racial profiling. So back in between 1933 and 1954, we had what was called Operation Wetback. Has anybody heard of that? Yeah, it was heavily in Los Angeles, and so there were a lot of Mexican folks or people of Mexican ancestry here. Some folks had been here when the border crossed them, and some folks had migrated like around World War I because there was a labor shortage, and guess what? The U.S. invited people from Mexico to fill those labor shortages. And during Operation Wetback, they deported over 2 million Mexican folks or people of Mexican ancestry. More than half of them were U.S. citizens. More than half. So how do you think they were picking people up?
Racial
profiling. Racial profiling. The color of your skin or the language that you speak. Right? And so they did this for decades, even as they were building bracero programs, inviting, again, farm workers to come in the fields. They're inviting people in, and then they have these very race-based programs to take people out, regardless of their status. And so we have seen the raids happen in Southern California, right? Where have we seen them pick people up? San Diego, where else? LA. What about what physically?
Home Depot.
Home Depot, where else? Car washes.
Schools, landscapers.
Schools, landscapers, people gardening, what else? Hotels. Farms. What are these people doing when they're picking them up?
Working.
They're working. And who do they look like?
Everyday people.
They look like a lot of us in this room, right? And so they are sweeping people up based on the color of their skin, based on racial profiling. And even though there was a lawsuit filed by people in LA, by these worker centers in LA that have been deeply impacted, the Supreme Court just upheld the racial profiling. They said, you know what? It's okay for us to do that. And we need to remind ourselves this isn't the first time in history that it's happened. So ICE officers are allowed by the courts right now to pick somebody up based on the color of their skin and based on the language they speak. And so how is this complicated? Does the color of my skin tell you what status I have? No. Of course not. So what statuses are they picking up right now? Everybody. Are they picking up citizens?
Yes. Of course.
Are they picking up legal permanent residents?
Yes.
Are they picking up people with DACA?
Yes.
U visa? Yes. Work authorization?
Yes.
DALE? They're picking up everybody. And so status doesn't even matter. They're not even asking questions. They're getting you and then figuring it out later. And so it's really important for us to know that we're in a worst case scenario right now. And so if you think that it's not going to hurt you or this doesn't apply to your facility, if you have people that look like the people in this room, it applies to you right now. And so please take this information seriously so that we can be prepared. Let's talk a little bit more about what's happening. So the administration, the new presidential administration came in January, right? First week in office, they started to move executive orders. What are executive orders?
Presidential orders.
Presidential orders, right? So they are orders that basically bypass the other two parts of government, and they become essentially a type of law of the land, right? They're not the same as like the law that's passed through Congress, but they have a lot of weight and they can be enforced. One of the first things he wanted to do was to get rid of birthright citizenship. So according to the U.S. Constitution, if you're born here, you're a citizen, right? Right? You're born here, you're a citizen. He wants it so that if you're born here, but you have immigrant parents, you don't have that same right to citizenship.
Isn't that all of us?
Isn't that like within a generation or so, right? Luckily, the courts struck that down. But you can see the theme that he's going. He's going hard and he's trying to use actual procedure and policy and legal powers that he has in order to do some very awful things. The other thing that he started to do was to implement quotas for detention, so quotas for daily arrests. We started in January with 1,200 to 1,500 daily across the country. That was the quota, meaning that ICE agents have to meet arrests every day. Kind of like how cops have to do speeding tickets, right? CHP has these quotas to catch us on the freeways. We're running a little too fast. Well, they want to pick people up. In June, he increased that to 3,000 a day. And what started happening in June here in our backyard? The raids, right? So these are driven by mandates that are coming from even above the Department of Homeland Security. They are being mandated to pick up people every single day. At this point, our detention centers across the country are over 100% capacity because of the detentions. And this is why we started to see an increase in the aggression, the aggressive tactics. So what tactics were they using here?
Pick you up and throw you in the ground.
Pick you up, throw you in the ground. What else?
Plain clothes.
Plain clothes. Okay.
Identifying themselves.
Not identifying themselves. What else?
Hold on to your kids hostage.
They literally held a little girl hostage outside of the house this week. Right?
What?
Yep, they held a 5-year-old.
You guys, you scare people. That's what you do. See how you have the kids over there? That's what you're doing with this country. Huh? You put it upside down.
Please, sir. She have autism spectrum. Please, please. Yes.
We can see your ID. You're gonna have to come out. Bring your ID. We'll check you too.
Okay. I'm gonna give you my ID back. Give me my daughter back.
No, you're gonna have to physically come out here.
They're using masks, but they're also going in teams. We're, even for I-9 audits, we're not seeing them, this is a paper raid, we're not seeing them come in with the notice of inspection, you're gonna have an audit, or mailing it in like they used to. They're coming in almost full SWAT tactical gear, right, to do this. Tear gas, everything. They're using all of it because they're trying to meet those quotas. Another thing that they're doing, which is legal, is they've expanded the discretion of ICE officers to do deportations without going through due process, without going through a judge. In the past, if somebody couldn't prove they were here for more than 2 weeks, so this usually happened at the border, when they caught people at the border. If you couldn't prove you've been here more than 2 weeks, a regular agent, a regular everyday officer, could decide to deport that person without ever having to go through due process or a judge. They expanded that to 2 years. And so if you can't prove you've been here more than 2 years, an everyday agent can just deport you, again without a judge. How many of us, if we got stopped, could prove with whatever's on our person that we've been here 2 years or more? Are we carrying leases? Oh, you can. She's prepared.
I carry my birth certificate, everything.
Okay, so
I carry my passport.
now you carry your passport, but a passport that might not be enough for them, right? If somebody has a legal permanent residency, even though to even get a legal permanent residency, you have to be here for years to get that green card. That's not enough for them. So she's gonna go over it, but leases, school records, bank statements, things that have dates on them. And so the expansion of the discretion that officers have is huge. And these are all things that are happening in real time. The other thing is, who's a criminal? He campaigned on, I'm going to deport criminals. And so what do we think of when we think of a criminal? Killers, what else?
Somebody with tattoos?
Drug dealers, what else?
People in pinstripes.
People in pinstripes. We have a definition of criminal based on our criminal justice system. Somebody who's done a robbery, theft, killing, all of these things. That is not what they mean by criminals. To them, the definition of a criminal is somebody who wasn't born here. Right? It's somebody who is a migrant. And so with that, they're able to expand too. Well, I'm getting a criminal because they didn't have the right paper. Right? So this expansion of definition has also been really big in who they're taking. And then the last thing we want to go over, let's see. I'm used to clicking on my computer. Is the money. So Chris Griswold talked about this earlier. They have all the money, honey. They have $170 billion over the next 4 years. Billion with a B. Right? It's triple their budget just for this year. And this money is going towards building new detention facilities. Not just for individuals, but who? Who do you think they're building facilities for? Whole families. So we're going to now have facilities for children and parents to stay together as they're deporting them. It's going towards recruitment. Who's heard of some of the recruitment tactics they're using? $10,000 signing bonus, student loan forgiveness. right? It doesn't sound like a bad deal. They have all the budget to do that now.
Yeah, NPR had a thing this morning, Harris and I were listening to it on the drive-in. They were at a job fair, a nice job fair. And it was pretty scary listening to the comments from the folks who were applying for these jobs, let me tell you.
They have whole families signing up together. It's gonna go into more transportation, and then it's going to the border. But they have a bigger budget than most modern countries have for defense. The entire country has for war. We have just to snatch people up right now. And so this is the context that we're living in. It's important to have all this context and know what's happening, because it's going to make what's happening in our shops make a little more sense. The last thing we want to know is who is doing this enforcement activity. So the Department of Homeland Security is the umbrella organization. This is the federal government agency. And under the Department of Homeland Security, you have ICE. These are the field agents. These are typically the people that are doing the sweeps and the arrests in a different administration. And then you have Customs and Border Patrol. So because California is along the coastline, and the coast is considered a border, if they have jurisdiction within 100 miles of that border. So a lot of California falls under CBP jurisdiction. They're allowed to set up checkpoints, and they're allowed to have enforcement here in much of our state.
Sorry. Question. So on the CBP jurisdiction, is that 100 miles from international border north, or is it also 100 miles inland from the sea, because that's also considered?
Inland from the sea.
Really?
Yes.
Well,
Yes, like
okay.
AFL attorneys. Yeah. Inland from the sea. So LA is completely
It's all
within.
over CBP.
Yep, we're completely within that jurisdiction. Citizenship and Immigration Services, and then we have HSI. So there are 4 different agencies that are typically doing enforcement. And because this is not enough to meet those daily quotas that they have, they've also been leaning on the FBI and the DEA. So they have officers here in Southern California doing those operations as well. Now, in other states, not in California, they can rely on local law enforcement. And they have a budget for that too. They have a huge budget just to reimburse sheriff's departments and police departments for doing ICE or immigration arrests. In California, that can't happen. We have a law where our local law enforcement cannot be used to do immigration enforcement. However, have we seen them on the streets?
Yeah.
What do you think they're doing? They're doing crowd control. They are legally allowed to protect the federal agents who are doing that enforcement. Logistics, right? They're managing the people around them. And so what ICE has done, if ICE feels they cannot do their duty, they can call the local law enforcement agencies to help them with their operation in that sense, in that logistical sense, right? Those officers can't actually do the arrest, but they can make sure that the other federal agents are safe. And so that is why we have seen our local law enforcement mixed up in the operations. It's because of that gray area that they're allowed to do. Now, how would we usually identify these people?
Their uniform. Badge.
Badge.
The vehicles they drive.
The vehicles they drive. That is not the tactic they're using anymore. So they are in plain clothes, or they're in general police uniform. They are masked. They are in unmarked vehicles a vast majority of the time. So it's becoming increasingly hard for us to identify which agency they're from, or what agents they are, right? Or if they're agents at all in some cases. But typically, these are the people that are doing the enforcement.
One other quick thing I would name about what we're seeing here versus other places is that part of this political agenda, right, is to go after sanctuary cities, right? Cities that don't collaborate, don't have law enforcement collaborating with ICE and doing that work. And so what's happening elsewhere is that because that collaboration is happening, folks are being taken from the prisons at their court hearings, right? They're doing things the right way, they're going to court. If they go without an attorney, they don't know what's happening, their cases are being thrown out, and then they get detained immediately walking out of court, right? So a lot of what's happening in other areas where you don't see the aggressive presence of ICE in the street, it's because it's just working within the system, right? Where they're just detaining them for a traffic stop, straight to ICE, right? They go to court for their checkup, hand it over straight to ICE. Here, because of that collaboration, theoretically, right, is not happening, they're coming to the streets and they're also making a, theatrical event out of it. So we're going to go into what then are our rights in the situation. And we like to talk about it in, both our offensive rights and our defensive rights. And for a room, I'm sure, full of sports fans, defense right is when the opponent is coming at you. What do you do when you're encountering immigration enforcement and truly any kind of law enforcement? What can you do? And these rights apply in those circumstances. I can get the clicker if you want. Thank you. A really, really important thing for us to all know is that these constitutional rights apply to all persons in the United States. So that means it doesn't matter if you were born here, if your generation's here, if you're here as a tourist for a week, if you just arrived into the country 2 months ago. These are your rights. There are parts of the Constitution that are specific to U.S. citizens, like who can run for president and what the rules are around that. When it comes to these amendments that we're going to go over, these apply to everybody. And so people should not believe anything different than that. These are their rights, regardless of their status. And so these rights kind of go a little bit in succession of how much protected you are in applying them. And the first is like your Fourth Amendment, which is your right to be free from unlawful searches and seizures. So what does this mean? It means that law enforcement, immigration enforcement, cannot go into areas where you have a reasonable expectation of privacy without a court-issued warrant, right? Without permission. So we all have this right to privacy in our homes, the most obvious place, right? The first place that we teach folks is that don't let immigration into your home without a warrant, a court-issued warrant. This is true for our vehicles, right? We shouldn't let the police search our vehicles, right, without some proof. And then this is also true for our workplaces, right? And that was explained a little bit earlier, but there are certain areas of our workplaces that are private. I think the really easy way to think about it, though, is that anywhere that the public can walk freely, ICE can be, right? So if the public can walk freely into a parking lot, ICE can walk freely into that parking lot. If the public can walk freely into the lobby or the dining area of a restaurant, ICE can do that too, right? We all know as patrons, we don't walk into the back of the kitchen. That's a private area, right, where only employees go. That's then an area where a warrant would be needed. And so that's really important to think about in our workplaces. Warehouses, if I pass by a warehouse, I cannot walk into a warehouse. Will ICE try to do that? Absolutely. But we need to make sure we know folks are trained to demand that proof and hold that line. And we'll talk more about that later. But this is such an important, right for us to know as individuals to not allow ICE into our homes, because the only other thing that allows our Fourth Amendment to be violated, essentially, is our own permission, right? Us allowing them in. So they either need this court-issued warrant or our permission to come into these private spaces. So think of it as a vampire, right? They can't come in without your permission, although they will try. But the other note here is that, the warrants, think about, getting a warrant issued by a judge, right? That takes some level of work. I think we're leaning more towards a legal system that is just not fully working well or justly. But in theory, you need to present some kind of evidence, right? Or some kind of case to a judge that says, here's the reason why we need to violate this person's Fourth Amendment, why we need to override this person's constitutional right to their privacy, and I need you to issue me a warrant to allow me to do that. Here is all the things I have that show this person is in this location. These, items that we want to seize are here at this address. That takes some level of work, some level of investigation, some level of proof. It's not impossible. They do it all the time. But they're probably not doing it. In fact, they're definitely not doing it for 3,000 people a day, right? So we know that they are not using actual judicial warrants to the scale at which they are operating right now. So most cases, they do not have this warrant. And we'll talk about what then they are using instead. That is very confusing to folks. But that's what is required to, override your Fourth Amendment. So that's a right that we have. Now, whether you're talking to them through the door, and when it comes to asking for that warrant, you want them to put it up to the window or slide it under the door. You don't want to open the door and talk to them about it. This is whether you have that boundary, right? The best case scenario is that we avoid detention by keeping them out of our private spaces. But if you're either in the public or you're talking to them through a window, through a wall, through a door, we have our right, our Fifth Amendment right, which is our right to not incriminate ourselves, right? This is, I think, the thing we see most often, in TV, on cop shows, right? Anything you say can and will be used against you in the court of law. It's as straightforward as that. I think often we feel in interactions with authority that we might be helping ourselves if we're being honest, or if we're trying to explain ourselves and say we didn't do anything wrong. Their job is to prove that their assumption about you is correct. And every question they're asking you is to get to the point of proving that what they have assumed, which we know they're now racial profiling, that folks don't have authorized status, whatever that might be. So their entire interaction is about building their case to justify what they have just done, which might have been unlawful completely, right? And so there is no reason to engage in really any conversation whatsoever in these interactions with law enforcement ever. Like, nobody here, no matter what context, does not help you to talk to law enforcement about anything, really. But especially right now with immigration enforcement, there's no need to say anything other than, I plead the fifth. I'm invoking my right to not speak. Did you want to add something?
Sure, I just want to add, in terms of what Claudia's saying about your Fifth Amendment right against self-incrimination, silence is golden in this area, right? We don't have to say anything. They can't compel us to say anything. You absolutely have the right to remain silent. And people need to know that that is a right that they cannot be moved off of. It's not like, you bring somebody, an employer brings somebody into an interrogation and says, well, if you don't spill the beans on Jim, Joe, and Betty Lou, we're going to fire you. They can't do that. They're gonna prosecute you no matter what, so you might as well not say anything that's going to assist them in gathering evidence that might be used against you.
Question?
Does Miranda right also apply to immigration arrests?
Absolutely.
Yes, absolutely.
Totally same thing, honey.
So
Absolutely.
they should be telling somebody that's being arrested that they have the right to remain silent and that they have the right for an attorney.
There's a lot.
And I think that's a really good point. Did everybody hear that? You have Miranda rights as a detained, alleged, undocumented worker. They must give you your Fourth Amendment Miranda rights. Anything that you say can and will be used against you in a court of law. You have the right to an attorney. You also have the right to remain silent, period. You got to read them those rights.
You change the card so they say shut the fuck up.
There you go. Right?
Vance, question?
Yes. Earlier you said something about documentation, rental agreements. People don't walk around with a rental agreement in their pocket. So what are the documents you're talking about that they could produce that are valid?
We'll talk about that. I'll come back to that, but we're basically saying people should start doing that.
Yes.
They don't. People need to start doing it.
Unfortunately, yes.
So, Fourth Amendment right, keep them, your best case scenario to avoid detention is to just not let them in, right? Also to not incriminate yourselves. All right, you've been arrested, right? You've been detained. Then we have our Sixth Amendment right, which is our right to counsel when arrested. A really important distinction here. Criminal court, if you cannot afford an attorney, you're provided an attorney. Public defenders, right? Immigration court, that is not the same case. It's similar to a traffic violation, right? Where you go to traffic court, no one's giving you an attorney, you have to bring your own attorney. Immigration court is the same. It's a civil violation, and so you have to provide your own attorney. You have the right to have one there. The government will not provide you an attorney if you cannot afford one or you cannot find one. And so it's very important that folks who are at risk start doing the work now to work through nonprofits, low-cost attorney agencies, or maybe have already their existing attorney at hand, because the government will not give you an attorney in the situation, but it's incredibly important that folks have attorneys with them or some kind of representation with them in these court proceedings, because that is what we're seeing again. Folks are going to court as part of their process, their asylum hearings, whatever that may be, and because they don't fully know the legal process because it's complex, right? Right now, the directive from DHS, right, is to get these cases thrown out. They move to do that, and then folks walk out and are now eligible for removal, right? And they get detained and removed immediately.
If someone gets arrested for immigration status, I understand that they have the right to remain silent. Are they given the right to an attorney? Is that a district attorney, or how does that work?
So that's what I'm saying. They have a right to have their own private attorney. Right. They have a right to bring an attorney with them and have an attorney present in their interactions with court.
But if they can't afford that,
then
they're
that's
out of luck.
they're out of
they're
luck.
shit out of luck.
You're shit out of luck.
Yeah. So that's why it's different than criminal, right? Where you can get a public defender assigned to you if you cannot afford it. These are civil. The same way, again, traffic court. The government will not give you one.
Does it have to be an attorney, or it can be an advocate of any kind, like from any type of maybe nonprofit type?
Yes.
Yeah, you can bring advocates with you. I think. Yeah.
Yes. There's like a notice of appearance that you can file actually to become the representative of someone who's been detained and someone who is subject to deportation proceedings.
So if they're, in a sense, if someone gets picked up and we're educating our members and their families on this, like, hey, here's a list of places that if you get detained, you need to call one of these people,
Yes.
they can advocate for you.
Yes.
Yeah, but let's also just be really transparent that right now immigration attorneys and advocates their caseloads are crazy, right? And so you want to try to do that work ahead of time to find somebody who you could try and already build some rapport with and that would be familiar with your case, so that should it happen, they already know what to do. And some of those forms are filled out.
If anyone has a question right now and they're concerned about their status or anything, they need to talk to an attorney or an advocate now. If you wait until you're arrested, that's worst case scenario. Yeah, so you need to have these conversations. It also might take a while because people are impacted, so if you do it now, you'll be more prepared if and when it happens.
Okay, thank you.
I do have a connection to an immigration law office, so I've got some cards for Sabrina. Sabrina DeMast is a good friend and colleague. Yes, her caseload, as like every other immigration attorney, is starting to get big, but I've got some cards up here if anybody wants to grab one. Please come up and grab one. More than welcome to call Sabrina, refer people to Sabrina if they have questions, if they have issues. And she knows and is waiting for a massive wave of Teamsters, so hopefully that happens.
And what Rosemarie said was that people who feel like they're at risk, and we'll double down on this later, should call an attorney now. Not when you're detained, right? They should do it now. If anybody's at risk or are concerned about possible detention, they should have that contact and have that conversation now, because if you're doing it once you're detained, it's already kind of too late, right? Yeah.
And it's really too late because, unfortunately, I think, in terms of the numbers, like 70% of the people who are being detained are going into the rapid deportation procedures, right? So if you're already detained, you're potentially within 48 hours of being on a plane to Ghana. So you want to have your attorney in place before that ever happens.
Yeah, I mean, what we're seeing also happen, right, is somebody will get detained here in California, in LA. Within a day, they're in Texas, right, at a detention center in Texas. So they're purposely also moving folks away from their families, away from their support networks, and making it more difficult for them to get the support they need. And so if you're at the same time trying to find your person, trying to find an attorney, trying to figure out like what you do now that they're gone, it's just overwhelming. So we'll go into the prep work, but it's really important that folks prep. Just doubling down on the right to remain silent again, because in any context, whether you're detained, whether you're talking through the door, we really need to uphold our right to not incriminate ourselves, because the simple way to put it is that the burden of proof is on the state, right? They have the burden to prove that you're here unlawfully, the burden to prove that you were not properly following procedure, that you're out of line, whatever that may be. And so they're going to try and ask folks what country they're from, when they arrived, what language are they speaking, because all these things are going to start to implicate, right, that they are not U.S. citizens, that they were not born here. And then from there they can start deducting different bits of information, right, that will lead them to further prove their assumptions to be true. And they might do this in a way that's kind and comforting in a very scary moment. Unfortunately, a lot of ICE agents also look like folks in this room, right? Because that's just the demographics of the country. And they might say, hey, no problem. My family's Mexican too. I understand this is stressful. It's okay. My mother's undocumented. Let's talk through this and I can help you. Just tell me this information and we'll figure it out together. They're not really trying to help you, right? They're doing their job. Or they might interrogate you and physically assault you and be really awful, and you might want it to stop. And you think that if answering their questions, that'll make it stop. All these things that could happen, right? That we're seeing literally happen. Or what Rosemarie mentioned earlier, which is where they held a man's daughter outside the house until trying to lure him out, right? And it would happen in that situation, so folks know, they eventually let her go because the local police came and handed the daughter back into the family, but they came back a couple days later and took the dad, right?
They took the daughter to the police department and had the grandma come pick her up.
Okay.
So we have a question up there? Sir?
Yes, you say that you don't have a right to an attorney when they do this.
You have the right to counsel, not to be given an attorney. Mm-hmm.
You don't have a right to a private attorney. You have a right to counsel, but not a private attorney.
Sorry. You do have a right to representation. It's a private attorney. You don't have right. They're not going to give you one.
Okay.
That's what I mean. Sorry.
My question is, if they are taking your right to freedom, doesn't that impinge on doesn't the constitutional guarantees kick into place then? And if their interpretation is that that's not the case, is there a move or is there a case going forward through the courts to fight that? Because that doesn't seem logical. If they can take your freedom,
Right.
then they should.
No, I agree. It doesn't seem logical, but it's pretty well settled. You know, again, I'm sorry. I'm going to avoid the editorial, but it's settled law that the immigration procedure is not equivalent to criminal incarceration, because the end result of the immigration process is either one of two things. You got to get your citizenship and you're allowed, or your work papers, you're allowed to stay here, or you're deported. You're not permanently deprived of your liberty, which is the test for a criminal proceeding. Permanent deprivation of liberty. When you're subject to criminal charges, you could go away potentially for the rest of your life, or you go away for a determined amount of time. The immigration service or the immigration system may detain you for an undetermined amount of time, but at the end of that undetermined amount of time, again, either you go free or you go away.
And just, a reminder, like our government, our country has been allowing these injustices since the beginning of this country's existence, right? Like, this is not new. We're seeing it at a massive scale with part of this like administrative political agenda, but it is an ongoing historic problem that we have.
So we're going to go into a little bit more practical knowledge, and we've gone over some of this already, but there are different in situations where we come into contact with immigration enforcement. And different rights apply depending on what those situations are. And we already know they can grab us where? Anywhere right now. So let's talk about the home. If they come to your house, you have a right to privacy. That is your own space. You are protected by the Fourth Amendment. What we advise, what attorneys have advised, is that you don't open the door. Even if you have a security latch, and folks have little chains, if you open it a crack, that can be seen as permission for them to enter. If you have a screen door and you open the other door, same thing, could be seen as permission to enter. So you want to keep those doors closed, right? And what you want to do is ask to see a what? Warrant. A warrant, and what kind of warrant? A judicial warrant signed by a judge. And they can show it to you through the window, or they can show it to you under the door. They're not going to want to, but that's what you have to keep enforcing is, I want to see a judicial warrant. You can slide it under the door, or you can show it to me through the window. And if they don't have the judicial warrant, they need your permission to enter. So don't grant permission. So when you're home, your Fourth Amendment is locked in, you have a judicial warrant or permission, and if they have neither of those, they cannot enter. Now, what do you think is happening?
They're entering.
They're entering,
Yeah.
right? And so in this case, they are being unlawful. We have seen them break windows to get a 75-year-old woman out of her house. They broke a window and went in. They have kicked doors down over by where I live in Ontario. They used explosives to blow open a door to get a family out of the house in Southeast LA. And so these are the things that we have seen them do. In that case where they act unlawfully, what you can do in the moment is limited. You can remain silent. That is the best thing you can do. If they are entering and taking you, they are unlawful, you will have legal recourse afterwards to fight your case. You should ask for an attorney or ask to see a judge when you're detained. But
I have a question, but it might be for the attorney. Where does the castle doctrine fall in place with this?
The castle doctrine?
Yeah.
I'm not familiar with that, I'm sorry.
That's your right to your home and your right
Oh,
to
castle as in C-A-S-T-E-L.
Yes,
Okay,
yes.
I thought it was like Cassellsburg.
No.
Sorry. So, it's the Fourth Amendment. The Fourth Amendment basically says that it's a private space, you have a reasonable expectation of privacy in the four walls of your home, and they gotta have a warrant. Unless they're in hot pursuit of a felon, or unless they believe that there is an exigent potential of massive public harm if they don't go into your house right away.
Because I can see this becoming eventually bloody.
Oh yeah, and we're going to talk about this issue as it relates to the workplace in much more detail in the last part of the session. But let me just say this real quickly. In terms of your residual rights, like after you're detained and you got beaten up and you want to sue, one of the most important things is going to be documentation, is proof. So we're going to talk about things that we can do to gather up that proof with cooperation of employers, or if they don't want to cooperate with us, how to do that to be able to help our members and help our community if they do have claims against outrageous conduct by ICE. In California, there is no such thing as stand your ground. We don't have the legal equivalent of that. So even if that dude, that ICE officer comes into your house and he looks like he is about to rob you and essentially do a home robbery, and you shoot that officer, you probably don't have a defense under California law, much less federal law.
We have a
Unless
hand.
you live in Texas or Florida or someplace else that has a stand your ground law.
I mean, some of the citizens have been released, and I know of at least 3 members out of like 200 of the Car Wash Worker Center that have been released on bond for similar things. So that's not a huge ratio, just 3, Lewis. Just 3.
I also want to say, like, even though we know they're breaking in, there's also a lot of examples where people successfully are turning them away by holding the door shut, by not allowing them in, by enforcing their Fourth Amendment rights. So it really depends on like what kind of flavor of agent you get that day. But you're better off trying to enforce your rights than just giving up and saying they're going to break in anyways.
Yeah, and then we're going to go into some of the things that are helping. When people are holding the door shut and then calling the rapid response networks, people can be out there in 5 minutes. There are groups of people that are trained right now across San Bernardino County, across LA County to show up when ICE is there. And there are whole networks that we can tap into. And so while you're fighting from inside, there's somebody else that can be outside documenting and diffusing the situation.
That federal officers often, as part of the, particularly ICE, will lie. And they're known for lying. And they will say that they are local law enforcement. Right? They might say, hey, we're just local officers, we're canvassing the neighborhood, right? They will not tell you always while they're there. And they do it often, as Rosemarie said earlier, they go in plain clothes. And these are just the tactics that we see. If they're going there at midnight, they're probably going in technical gear with the intention of getting in no matter what, right? And they probably have more defense items than you might have if they're going in that way, right? So I would just keep that in mind.
In the middle of the night, hundreds of armed federal agents and police, backed up by riot trucks, smoke grenades, and helicopters, breached fences and busted doors in an immigration raid on an entire apartment building on the city's south side. They pulled dozens of residents from their homes and zip ties, including children, some of them without any clothes. They then held some outside for hours and dragged the others into rented vans.
Claudia's correct. So basically, your apartment is your personal space. Yes. So that is your protected space. Basically, they have no right to enter there. But for instance, if it is like a courtyard of a building and the owner of the building lets them into the courtyard, then they're there under the permission of the owner. And I would say that's kind of the same if another tenant would let them in too. But your personal apartment, that's your space, that's your private space, and you have Fourth Amendment right to that.
Now, are there any exceptions to that? Let's say it's come up with a scenario. Let's say it's somebody who hasn't been able to go to work because they're afraid they're going to get detained, so they're behind on the rent. Is there an exception to that where the owner can come in because that tenant is behind on the rent?
Well, I mean, that's a good question. So, because that gets in kind of the interplay of like tenant, landlord-tenant law, and then also, the interplay of immigration and labor law. And what I would say there is just generally, if someone's going to be evicted, they would have to go through the entire eviction process to actually get them out of the house.
Depending on where you work, there are typically private areas and areas open to the public. We established this earlier. I think for a lot of your members, there's going to be a lot more areas for privacy. This is the time to mark those. If there's not a sign in the parking lot that says employees only, now's the time to do that. If you don't have these signs on every fucking door in that building that's private, including the front door, if it's authorized personnel only, that is the time to do that. You all have the power as business agents, and your members have the power to demand that of the workplace right now. Other important part. If you don't have a policy of who's allowed to grant permission, right, because the Fourth Amendment says warrant or permission, you need to have that right now. In your facility, who is allowed to let unauthorized personnel in? Is it just management? Is it the security? Is it reception? Is it any staff could do it? But you need to know right now and lock that in, who can and who can't. Because if they come to me and I'm just a regular employee and there's a privacy sign and they say, we don't have a warrant, but we want to enter. I'm sorry, I'm not the one that can give you permission. You have to talk to my manager, they're not on site right now. That is a way for your member to kick it down the road, right? And so these are the things we need to do in our workplaces right now, because businesses have a lot of power right now to be able to prevent things from happening. And so we need to lean into that power. If you're in public, a little bit shit out of luck, they're not supposed to be able to go up to anybody. They're not supposed to. They have to have probable cause, reasonable suspicion, but again, what are they using for that?
What you look like.
What you look like, racial profiling. So that's what's happening. Typically, anybody can't just go up and snatch you. But if they're looking at the color of your skin and maybe you said something in Spanish, then that is their probable cause, and that is how they're taking people at the moment. The best thing you can do is ask, am I being detained or am I free to go? And if you're being detained, remain silent. The information you do have to share is your name and your birth date once you get booked. Right? But you don't have to affirm any other information other than that. If you're in your car, if you're getting stopped at a checkpoint or if you're getting stopped for like traffic, they can ask for your ID. Right? You have to show them that you're able to drive legally in the state of California. You don't have to give them more information beyond that. And if they don't have a warrant, they shouldn't go in your car. But what are they doing? They're doing it anyway. They're breaking windows, folks. This is how they're getting folks in the car. So we have to know like what is the law and then what's the reality for what's happening so that we can be prepared. Next slide.
I'm gonna pass this right.
So Claudia's going to pass out the warrants for you and these signs. So we have these signs. These are open source signs. You can scan the QR code and you can print them out for free. You can laminate them, give them to your employers. We even have like clients and employees only, patients and employees only, depending on the facility. We also have packets of these in the back, so everybody can go home with 4 signs, put them up in your workplaces. These are the signs. And then there's a warrant here. Claudia's passing it around so you all can see. You should print these out, take a picture of it, put it in the workplace, because it's a little tricky when they're interrogating you to look at this information and make sure it's the right one. So you want to study this or have it easily accessible so you can look at it while they're giving it to you. So a judicial warrant has the name of a court, United States District Court, or the name of a court on it. It has a date. It has to be within 14 days of today. So if they come with a warrant from May, that is not a valid warrant. But if they come with a warrant from September 22nd, that is a valid warrant. It is signed by a judge, and there's typically evidence attached to these warrants because they had to go through a process in order to get this warrant. And so there's documents attached. Now what they're using are these Mickey Mouse warrants right here on the right. This is printed from...
That's a legal term, by the way.
Yeah.
Yes.
U.S. Department of Homeland Security on the top. It's signed by a regular agent. It will say warrant on it, but it's just a piece of paper. And sometimes it doesn't even have a name so that they can write the name on it when they're in person. So we want to be careful to not give up our rights when we see an administrative warrant and know when to comply if it is a judicial warrant.
Documentation is incredibly important, whether it's happening to you or you're witnessing it. There is a ton of unlawful activity. A temporary, unfortunately it did not last, but a restraining order was won because there was so much evidence, right, to prove that this was happening unlawfully. And so if you're able to, you want to safely record these interactions. And one thing I want to make sure is really clear is that, look, ICE does not have jurisdiction over U.S. citizens, right? But what they can do is charge us with obstruction and interference, right? And that is what they are doing. That is what they are doing, right? When they take citizens, they end up just mocking up charges of interference and obstruction. But in terms of having safe distance, you want to make sure that they don't then pull you in. We know that law enforcement has a history of taking people's phones when they are being recorded doing things unlawfully, and so you want to try and record in a way that when you're recording gets uploaded to the cloud quickly, or you're doing it in bursts. You want to remove, this is a moment, unfortunately, y'all, I know it's so convenient that we have Face ID and thumbprint access. We're in a time now, things are changing, where you don't want to have biometrics on your phone, because then they can take your phone, get in it, and either find stuff or delete what you just captured. So those are just things to be mindful of. As you're taking notes of what happened, really important to document which agencies were involved, if you're able to take note of that, how many people were there, how many folks were detained, what was the date and time of incident, was there a judicial warrant, or was it the other fake warrant, right? Any other details, was anybody assaulted as a result of the encounter? Where did it happen, on the street, was it a raid, was it at a home? And then also, we'll share this more later, but you want to reach out to a rapid response network, so then you can share this information to them. And what they will do is then help do some of the follow-up support. So if you can and you're able to get engaged with folks who are being detained, you may want to ask for emergency contact information, because what is happening is folks who are being detained without witnesses, or witnesses cannot gather this info, is that their families just don't know for hours, if not days, what happened, right? People are getting disappeared at work, on their way to go pick up groceries, just like literally walking, right? And so if we can gather that information, we can help more quickly, so get them connected with their family and support network. All right, we're gonna move a little quickly because I know we're over. But yeah, as we mentioned earlier, like this is happening, you all are seeing it. At this point, there is no excuse to not have a plan in place. And this is true, honestly, because they're taking citizens, all of us should really have a plan for what would happen and what attorney you would call, or who you would call if this happened to you. But especially our members or folks who are at risk, or loved ones of ours that are at risk, we believe, of any possible detention. So what does that mean, and what does it look like? Rosemarie said this earlier. If you believe that you are at risk, or somebody you care about is at risk of possible detention, your status maybe is unclear or in process, you should have a checkup with your attorney, or be in contact with an immigration attorney or advocate yesterday, right? Like, you need to know where you stand, especially because things are changing every day. Every day there's some new random executive order. Stephen Miller is on whatever kind of kick he's on to try and make life more miserable for immigrants every day. And what would not have mattered a couple of years ago can now get you to lose your legal permanent residency that you've had for 2 decades, right? Folks are coming back into the country, going through Customs Border Patrol with green cards, and not being allowed back in because of a DUI from 4 years ago, right? Things that did not matter before, and now they do. And so obviously we cannot answer specifically what might impact your case, but those things are impacting people's people's immigration status now. And for green card holders, that seems unprecedented. When you're a green card holder or legal permanent resident, you feel like you're pretty safe. You're already kind of past all these processes, right? That is no longer the case. I mean, there's folks now, they're talking about plans for how to go after naturalized citizens, right? So anything shy of being born here, which even then, like if your parents were not born here, they're still trying to go after you, right? It's really important that folks get an understanding of personally what their risk level is based on what their history is, what their recent interactions with law enforcement were, and how that might impact them. And also how just the different policies are changing. We'll talk about temporary protected status in a second. You gotta know which documents to carry, which ones not to carry. We talked about this earlier. If you are a green card holder, TPS holder, you're supposed to carry that with you. You do have to actually carry those documents with you. If you're a U.S. citizen, you do not need to carry your passport, but I understand why you're doing it now, right? But they do not have the authority to ask you for that, but I get it. You don't want to carry false documents, because that, again, builds their case. It's unlawful to carry false documents. You also don't want to carry documents that show nationality from a different nation. I know growing up, a lot of my family members carried their Mexican matriculas because that was the only ID that they had. That is not a thing that you want to be carrying on your person right now. You want to, again, have that phone number available of that immigration attorney. And then the kind of most challenging thing to do, but really the most urgent thing to do, is have a conversation with your family about what would happen if you did not come home for a couple hours, for a couple of days, or indefinitely. Who's responsible for picking up the children? Who has the authority to do that, right? Have you gone? And if it's you and you were to go, missing, essentially, who else is authorized to pick up children? Have you gone to the school and say, I authorize these other people to do this, right? I allow them to pick up my children. That's something you have to give authorization for, right? Do you care for somebody in the family, maybe an elder or somebody of special needs who you give medication to, or who has a special routine? Who else could assume those responsibilities, right? Who pays the rent, the mortgage? Who knows access to the accounts? Who knows the different inner workings of the household. If a foundational member of the family goes missing, does somebody else there know how to take on these responsibilities? At the same time, they're trying to fight for you to get released from detention. That's incredibly stressful, incredibly overwhelming. And if this is a possibility that could happen to us, we want to make sure that our families are best equipped to be able to sustain themselves as this happens, but also be ready to fight to have us released, right? And so there's a whole list. I don't know if I know it's in the resources that we'll share later, but is this in the packet too? Okay, well, we'll share some little family preparedness checklists that we have. But yeah, you want to make sure that you're making all these plans. Again, earlier Rose mentioned about the now that they can remove folks who've been in the country, they suspect have been in the country for less than 2 years. So we are recommending that people carry a copy of their lease or a bank statement that shows proof that you've been in the country for over 2 years. And it's not something people normally do. Y'all are right. But now it's something you actually should do to be able to not be immediately removed from the country. For folks that have any type of status, temporary protected status, they're documented, they're in asylum, U visa, really important again that you carry your documents with you, that you assess your risk when traveling, right? If you travel out of the country, you are choosing to put yourself through DHS, right? You're going to go through customs and border coming back into the country. That's a choice that you're making. Will they let you back in? Do you know? Or will they, when you go through the process, will they find something that then causes them to detain you and not allow you to come back in? A choice that you all need to make. We got to prepare for increased fees as part of that new legislation, right? For example, TPS registration fee has gone from $50 to $500. So they're making this inaccessible for people, right? For the folks that are doing it the right way, they're wanting to push more people out of that process and into limbo. And again, just tracking the changes. So I think we all heard on the news, right, for the HB1, maybe not all of us, but we heard recently there's an executive order about HB1 visa holders. This is usually folks that work in engineering and tech. There's now a $100,000 fee that they want to put on folks that apply for those types of workers. There was people literally on planes ready to leave the country, got off the plane, right? It's still a lot of unclarity on how that's going to be implemented. They did not want to risk it. Because again, things are changing every single day. And so it's very important that if you have a status, that you are tracking it, again, true for your loved ones and true for your members. Because what happens when you lose your status? You lose your work permit, right? And this is going to be really key, I think, especially for folks in our movement here in LA, for TPS, right? We have a lot of TPS holders in our memberships. They're now terminating a lot of those TPS statuses. They're not renewing them. Many are expiring this year. Some will expire next year. There's been a couple that are in contention, that are in litigation, but we're not seeing any movement to renew TPS. Folks that have had TPS for years are about to lose TPS. We know some employers have actually moved to preemptively fire TPS workers because they're going to ultimately lose those work permits, and so they don't want to wait for that to happen. And so these are just things that you also need to think about as reps, because you have members who are working with work permits right now that will lose them if TPS goes away for them. So things that those folks can do is start to see if are they eligible for a different kind of status maybe. Could they, they want to be, if there is room to re-register, that they're on top of those windows. Mm-hmm.
You have a list, or can you mention those countries that are on the chopping block?
Yes, I can mention that right now. Give me 1 second. Essentially every country is on the chopping block, but so in this year we're gonna see Syria, South Sudan, Honduras, Nicaragua, Burma, and Ethiopia lose their TPS. Next year it'll be Venezuela, Haiti, Yemen, Somalia, El Salvador, Sudan, and then Ukraine. No extensions have been announced there. Okay? And so, but again, really key that we check in with immigration attorneys to know what that status is. It changes all the time.
Sorry, so we know we've been a lot of, a lot of doom and gloom. It's just the reality that we're in. But people are fighting back. And so there's a series of legislations. There are actually 5 policies that Governor Newsom signed over the weekend that many of them go into enforceable right now. So he put an emergency clause on it. Typically, when we sign something in September, we have to wait until January for it to become law. A lot of them are open now. So what it is they're around schools. If ICE comes to a school, now that school has to, it's mandated, notify the parents, the staff, and the students that ICE is present. There's more restrictions on the warrants. So like we know they have to show judicial warrants. Now it's in state law, so we can back it up with the state law that officers have to show warrants for these things. So some of it is just codifying what we already have in certain code. But the state of California is really trying to make sure that our communities are safe and that there's something they can do about it or put some muscle behind it. We also have people that are building mutual aid networks. So I know of a lot of people in my family who are afraid to go to work, who aren't leaving the house right now to go get groceries. I have a tia that's about to get evicted right now because of that. There are mutual aid networks, right? We have rental assistance in certain cases. We have food. There are people donating groceries every weekend going to do sortation. And so you should really tap into these resources if you have people that are hard-timing it because they're there. And labor is really good at showing up for our people. So another thing is we have people that are volunteering daily to go talk to businesses and workforces about their rights. So the same presentation we did today, there are groups of people who are just on their free time going to little business corridors and just talking to these employers who might not know what to do. Some people just feel helpless. And I worked with Lane. Do folks know Lane, the Los Angeles Alliance for New Economy? So this summer they ran a program where they talked to over 9,000 businesses with canvassers, handing out these same packets, helping people put up signs, and then going before a business open, like at 5 a.m. or after it closed in the night, and giving these trainings to the workers. And these are things that we can be doing, right? We can be offering these types of things to our employers right now. Even help bringing tape in the signs. Oh my God, people were they thought they had to pay for these. And so these businesses that are also struggling because they're losing business, we can give these things out for free. And some of the businesses we visited were clinics. Clinics are losing so many patients right now. Some of them are starting to have policies where if somebody has an appointment, they have somebody escort them from the parking lot into the building so that they feel safe. We have to start thinking about all these workarounds with different employers or different businesses. We have other businesses that are going back to COVID times where they lock the door. So you can order on the phone, you call when you get there, they'll unlock the door, hand you your hamburger, and then lock it back up. These are not bad business practices at the moment, right? And they can do that. So these are some of the things that people are doing to fight back. Last slide.
You have it.
Oh, I have it. All right. So, what rights do we have? You guys are failing this quiz, you guys. The amendments. What amendments protect us? 4th, 5th, and 6th. And what should we be doing right now? Preparing. Yeah, get your shit in order. This is the time to prepare. And then the second one, that's another presentation. That's a different presentation. There's really no excuse right now for us not to be prepared, and there's no such thing as over-preparing. You all have a lot of power to go back to your employers, to go back to your members, right? To start thinking about these plans, the policies that we have in place, to role play. If folks have ever been stopped, who gets nervous when they get stopped by the cops, even if they've done anything wrong? I get so nervous when they drive behind me. All of this just goes out the window. So if we start role playing right now, even if it feels a little funny, we are going to be more prepared. But we really have no fucking excuse at this moment to not be prepared.
You know it's coming, right?
Yeah, it's coming.
You know it's coming.
We are in worst case scenario. That mode is activated.
Am I being detained? Am I free to go?
Yeah.
Only thing you gotta say. Am I being detained? Am I free to go?
Yeah. All right. Back to Lewis.
There we go. The last 45 minutes or so here, we're going to talk about 2 buckets of specific training issues, and within one of those buckets, 3 sub-buckets that are going to be really important for our workplaces. So number 1, educating our members is going to be one of the most critical, if not the most critical pieces of this program. If our members don't know their rights, if our members are unfamiliar with how to exercise those rights, what to do, how to do it, when to do it, they're going to be at risk. Our ability to protect them and represent them are going to be at risk. Unfortunately, those people are probably going, if they do get ensnared in a dragnet, they're probably going to get deported. And so basically what the program should be to get ready is hopefully membership meetings like we're having now. Membership meetings where maybe Rose and Claudia show up, or if you want me to show up, be happy to do it, but really going over these issues with our membership, bringing our membership up to date on the fact that this is a changed environment. This is not the United States of America from 2022 or 2023. This is the United States of America in 2025. We have to carry papers now, and it better be the right papers. Because if you don't have the right papers, that could be probable cause for immigration to detain you and then deport you. And so, again, membership education is going to be absolutely critical to making a program of protecting our flock, our people, work. And, again, educating people on the three amendments that give us our constitutional rights, the Fourth Amendment, the Fifth Amendment, the Sixth Amendment, and maybe later on the Second Amendment. Locals should be thinking about individual programs to bring their members in and to educate them on these issues. Bringing members in to talk about how to plan with their families in the worst case scenario. Establishing, as Rose and Claudia were talking about, relationships with community groups, having people make their plans, number one. Making sure that people, again, have the right paperwork and are carrying the right paperwork to establish that 2-year residency at the very, very bare minimum. And what's important about the 2-year minimum residency rule is that will generally exempt someone from the rapid deportation program. The folks that are generally being deported in the rapid deportation program are people who, number one, have some type of criminal record, but also people who are unable to establish that they have been residing in the United States for more than 2 years. And so again, that type of paperwork is going to be extraordinarily important to establish that somebody is either a citizen, if you've got a passport, or you have your birth certificate with you, or in the case of a green card holder, you've got your green card with you, whatever other documents that are going to establish, again, lease papers, as Claudia and Rose indicated, bank statements, crazy stuff that we never had to carry before. We want to have membership training programs. We want to focus our members on what their rights are, especially the right of privacy and how that relates to searches and seizures. And that the Castle Doctrine does apply if you're careful about exercising the rules. And what Claudia and Rose said is absolutely correct. Give a law enforcement representative an inch and they will take, they'll take the entire world, right? So you don't want to give the opening to law enforcement to come into your private space. Our private spaces are protected by both the federal Constitution and the state Constitution. Again, we want to make sure that our people are, if not connected to a specific immigration attorney, that they are connected into a community organization that can get them hooked up with an immigration attorney in the worst case scenario. We want to educate our members on accessing platforms that can hopefully lead them to where a loved one is if, in the worst case scenario, a loved one is detained. That's going to be very important. We talked about somebody over here raised the question of, do you have to be an attorney to represent an individual before ICE? The answer is no. But you have to fill out very specific documentation and paperwork to file that with ICE in order to become the recognized representative for a detained individual. And so, again, we want to educate family members on how you do that so you can get visitation rights to your loved one if they are detained. And so I think the first step in our process is massive, massive, and immersive membership education and making sure that our members understand that this is a new day, it's a new time, and we have to be prepared for that, we have to be ready for it, even if it's uncomfortable, even if it takes us out of our comfort zones and how we used to live in the United States of America. This is America 2025, folks. It's different. And people have to understand that reality, and they have to plan for that reality, and unfortunately, we got to live in that reality. And that means getting ready for all this. All right, let's move on to the second bucket. Second bucket is what we can do with employers. And at specific very specific points in time what we can do with employers to protect our bargaining unit employees, to make sure that their rights are upheld, and also so that the employer understands that they have a cooperative partner in a relationship that is designed to keep the employer in business, to make sure the employer's business is uninterrupted, and employees remain productive and, to the extent possible, happy and satisfied. All right, so there's really 3 points in time at which immigration issues, immigration enforcement really connects with us. And those 3 areas are, number 1, if there's an I-9 audit at the employer's office. And the I-9 audit is basically an administrative review of the employer's personnel records. I'll get into it more deeply in a minute. Number 2 is when there's an actual raid. The raid is going down right now. What do we do? So the second bucket is you're in the middle of the raid. What's your response? What are your rights? What can we do? And then the third area is the aftermath of the raid. What can we do in the aftermath of the raid? How can we come to the assistance of any employees who were caught up in the dragnet? And what can the employer do to help employees at that point as well? And whether that's through the collective bargaining process, or maybe the employer getting involved and connected with community groups that are going to help support employees in the aftermath of a raid. All right, let's focus on the I-9 audit. Number 1, as we talked about before, I-9 comes from IRCA. IRCA is the Immigration Reform Control Act of 1984. Who was president in 1984? Anybody remember? Anybody that old? Ronald Reagan. Who signed this law into existence? Ronald Reagan. And was it a pro-immigrant law? It was. Ronald Reagan signed a pro-immigrant law into being. By the way, anybody know what else Ronald Reagan did that's totally out of the box and would surprise everybody in the world? That too, but I've been hiding that tape for a while. Where's our public sector folks? All right, where's Ray? Jason, what did Ronald Reagan do that specifically applied to the public sector division of 986?
Fire the air traffic controllers.
He did that too, but before he fired the air traffic controllers, well familiar with the Myers-Millis-Brown Act? Okay, Myers-Millis-Brown Act gives collective bargaining rights to local employees in the state of California, right? It was the first collective bargaining law in the state of California for public employees, right? The law was passed in 1967. Who was governor in 1967?
Reagan.
And who signed the law? Reagan. Yeah, and who actually lobbied for that statute? Ronald Reagan. Go figure. Okay, so anyway, IRCA required for the first time that employers actually do things to confirm that people they're hiring are actually lawfully allowed to work in the United States. So this means that the employers, after IRCA, have to maintain paperwork that establishes they went through due diligence to investigate the background of the employee and make sure the background of the employee indicated that employee was legally authorized to work in the United States of America. So employers are supposed to have some type of backup documentation to establish that the worker, in fact, is legally authorized to work in the U.S. Usually, the employer will take a copy of your driver's license or work authorization card. They don't have to do that. It's not a requirement, but most employers will do that as best practice. One of the other things that comes out of the IRCA system and I-9 system was the development of E-Verify. E-Verify was not part of the law, but it developed as employers in the late 80s and early 90s were looking for an easier way to access federal database to make sure that, for instance, Social Security numbers were accurate and not basically cloned, or that when you're hiring somebody, they didn't have the Social Security number of somebody else. Now, the other thing that IRCA established for the first time, and we talked about this in the first half of the class about the Hoffman case. It established that it's actually now illegal. It's a federal crime for an employer to knowingly employ someone without work authorization in the United States. Those violations, of course, would carry fines, potentially jail time, et cetera, et cetera. But, of course, as we've seen since the passage of IRCA, those types of prosecutions are extraordinarily rare. I don't think we've had one in Southern California. The only ones that I'm aware of are prosecutions that have happened in Iowa and I think Nebraska at large beef processing plants that had essentially, just opened the gates and hired anybody without checking. A little ironic note about that, most of those facilities were kosher facilities. Okay, so we have this I-9 thing, the employer's supposed to keep records. What do we care about that? Well, we care about that because the main enforcement tool that ICE used before 2025 was the I-9 audit. And the I-9 audit is an administrative review, and that's where these funky looks like a search warrant kind of thing comes in. It's called an administrative warrant. And the administrative warrant allows ICE to go to an employer and knock on the employer's door and say, we'd like to look at all of your employment records to verify that you have complied with IRCA and that you have documentation that shows that all of the employees you've hired over the last 3 years are actually authorized to work in the United States. And under IRCA, once the employer gets notice of an I-9 inspection or audit, they have 3 calendar days to produce the data to ICE. And the employer cannot withhold any of that documentation from ICE. They got to turn over everything and anything that ICE asks for. And again, because this is an administrative search pursuant to a statute that requires the employer to have this data, you don't need a judicial search warrant to get at this information. So ICE does not have to have a judicial warrant signed by a judge to do the I-9 audit. This is just, they call up the employer, we want to come in, inspect your stuff, we're going to email you the administrative warrant, thank you very much. Well, again, why does this involve us? What do we care? Well, obviously we care because if an I-9 audit shows no matches or raises suspicions about any employee, that employee, number one, is going to be in trouble with their employer, potentially exposed to legal issues with ICE. So we want to kind of make sure in advance that we're prepared for all that to happen. So again, an I-9 audit, to the extent that it triggers employer reactions that relate to our terms and conditions of employment, it affects employment. It affects the scope of representation. And we're allowed to demand effects bargaining over it. And in our effects bargaining, there's quite a few issues that we could and should cover in order to develop a cooperative plan with the employer to respond to I-9 audit requests. So number one, we want to make an effects bargaining demand even if the employer has not been subject yet or is not on notice yet of an I-9 audit. It may happen, it may never happen, but to the extent that there is a potential that it could happen, it still has the potential of impacting terms and conditions of employment. We should ask to bargain with the employer about how the employer, of course, is going to respond to the request for documents from ICE. And there should be 3 handouts, 3 separate handouts. We got it. Okay, good. Okay, so let's go to the I-9 information request template. So I've prepared for, if anybody wants to copy and use these, you're absolutely welcome to. These are all templates for your use. These are all for, obviously, local unions to use in connection with effects bargaining over these issues with employers. And if anybody has any questions about these templates, please feel free to give me a call, and I'll walk you through them, and we'll spruce them up and get them all nice and pretty to send to your employers if we need to do so. So the purpose of the I-9 bargaining demand information request, number one, obviously, we are demanding bargaining over the effects of a potential I-9 audit on our bargaining unit. And the effects, again, are, if the employer asks, well, people can be terminated. People obviously could be detained by ICE. Obviously, folks get nervous if they understand their personnel records are going to be rummaged through by the federal government. So all of these things affect terms and conditions of employment at the workplace. So, Mr. Employer, we do get to bargain over the effects of the I-9 audit. So there's three things we want to ask the employer for in our bargaining demand. I've got them noted in the info request portion of the bargaining demand. Notices from the federal government of an upcoming I-9 audit, or frankly, any notices they've received in the past, so you can determine whether or not the employer has any experience with dealing with I-9 audits. I think that's important because if you have an employer that has experience dealing with I-9 audits, they're probably going to be more willing and able to work with us to develop a plan because they know it's a reality and it can happen, as opposed to employers who don't have any experience with that, who are like, come on, when is this ever going to happen? They're never going to come here. For California, we have this wonderful thing called the California Public Records Act. The California Public Records Act pretty much makes almost every document in the state of California a public record, which means there's no privacy attached to it. If a public employer in this context attempts to raise privacy issues, things like that, well, those are all off the table because those personnel records are actually all public records and probably would be producible pursuant to a CPRA request, and therefore there's no privacy interest that the employer can assert in the public sector to stop us from participating in that. And then number two, if you have an employer who does have experience with the I-9 issues, give us a copy of your plan if you've developed a plan based on your last experience with ICE and going through an I-9 audit. We want to know from the employer if this is an imminent situation where the employer's already received notice from ICE that they're going to be undergoing an I-9 audit. When is that going to happen? Where is it going to happen? Who are the employer representatives who are going to be present with ICE? And there is nothing in IRCA or any other place in federal immigration law that bars a union from observing the I-9 audit. So we can ask the employer to be there, to observe the audit. We don't have the right to interfere. We don't have the right to eject ourselves. That could be interference with a federal officer. We don't want to go there, but we do have the right to request from the employer the ability to be at the I-9 audit and observe what's going down. Two other points with respect to the I-9 issue. Number one, employers can always perform their own self-audits. And maybe we want, in advance of an I-9 inspection, again, planning for something that may never happen, the probabilities are it will happen, the employer can perform a self-audit in advance of the I-9 audit. And through the self-audit, again, hopefully through some type of agreement with the union, if we identify people who are having issues, then we can give those individuals the space and time to get it right and to come back and establish that they have the right to work in the U.S. and therefore alleviate any problems or concerns that in an actual I-9 audit that individual will be identified, potentially detained by ICE, and end up in Ghana. So a self-audit in advance of the I-9 process with union participation to identify people who might have problems and help those people get their problems fixed is actually, I think that's the gold standard of how we approach the I-9 process. If we know from anecdotal evidence that there are folks at that facility, one of our bargaining units, that do have issues, they should be encouraged to the extent that they can fix those issues to get it done yesterday. Don't want people who we know have issues, potential issues in terms of the documentation they provided the employer, to be essentially walking around with targets on their backs in the event of an I-9 audit. Because those are the people who are definitely going to stand out. They will definitely be the people who are identified. And they will definitely be the people who ICE is going to want to come after and detain and eventually deport. So, any questions about the I-9 process before we move on? Dave!
So the I-9, they notify the employer they're going to come in and do this audit. They come in, they audit by 92 folks. They've been there for numbers of years, greater than 2. And then is the ICE folks thing going to say, I want to go look at this guy, this guy, and this guy, when they've been there much longer than 2 years?
Totally. So when you're doing an I-9 audit, the enforcement officer is not necessarily looking for the length of residency or length of work or anything like that. What they're focusing on is the truth or falsity of the documents that you, the employee, first gave the employer or gave the employer at the time the employee was hired to prove that they were here legally and can work legally. So it's not necessarily length of your status or family members or origin of country. It's what was the document, what are the documents that you gave the employer to rely on to show that you had the legal ability to work in the U.S. And if you gave the employer a false document, number one, that could be a crime. And number two, that essentially is automatic probable cause that you're not legally here, that you're not legally working, and that you are subject to deportation. Sir.
I think one of the previous slides said IRCA requires them to keep the documents for 3 years. So if an employee has been there more than 3 years, then they shouldn't have an I-9 to turn over in the audit because they're not required to keep it. So how do we impel the employers to not keep the or turn over those? I think that kind of goes that, I think the 2 years was that statute, but with the 3-year rule, these people, like you said, with the car wash working there over 10 years, shouldn't be subject to that.
Really good question. So, IRCA requires that the information be kept for 3 years. But the employer still has an obligation to make sure that everyone who is working at their facility is legally able to work. And so what IRCA does is it imposes a continuing obligation on the employer to basically get from the employee, whether it's through a verbal conversation or additional documentations, confirmation that the status the employer relied on to first hire them is still in existence, right? So, okay, 3 years have gone by, Fred, we're gonna get rid of the supporting documentation in your file, but just wanna make sure you're still legal, right? And that's sufficient for purposes of the continuing documentation of I-9 status and I-9 verification. So let's move on to our worst case scenarios. We get raids. We got a raid. So Claudia and Rose pretty much went through this, but what is a raid? Well, number one, ICE agents show up without warning as part of the investigation into an employer or a group of employers in that area, like what happened in Paramount when the raids first started. They're always unannounced, unlike the I-9 audit. These raids come out of the blue. They're not announced. There's no obligation for ICE to give any prior notice to the employer. So they just show up. Multiple federal agencies and pretty much no coordination in terms of the detention of individuals with local authorities. As we discussed before, maybe traffic control, stuff like that, but local authorities are not supposed to be acting in coordination with ICE. Obviously, the raids seek to create an atmosphere of instability and fear within the workplace. When people are afraid, they don't think clearly. If you're not thinking clearly, the more probable you are to fall into the clutches of ICE. Don't want that to happen. Very important, we're going to talk about this. They're usually warrantless. ICE usually shows up without a warrant, and they pretty much expect the employer to let them in, or an employee who doesn't know the lay of the land in terms of constitutional rights to say, yeah, come on in. I got no problem. You guys all look friendly. Sometimes they are based on a judicial warrant, and this is very important. Warrants are directed at one of two things. A warrant could be directed at an entire facility. So everything within that facility can be searched pursuant to the warrant. Or the warrant can ask for the arrest of a specific individual. In which case, if it's for a specific individual, ICE has to go to that individual. They cannot dally around and look under tables and behind machines and things like that for other people who may be hiding from them and other people who may working with legal authority. The raid can be in connection with an I-9 audit. I haven't heard of that since the raids have started. I-9 audits now seem to be secondary, where they were the primary enforcement mechanism. Normally, the raid will seal off the facility. Obviously, you want to seal off the facility to prohibit anybody who ICE feels should be taken into detention is actually detained. And last, but certainly not least, anyone who physically interferes with the raid is interfering with a federal officer. It's a crime. David Huerta from SEIU was arrested, I think, on the first day of the raids in Southern California, and he has been charged with obstructing and interfering with a federal officer in the course and scope of that federal officer's duties. It could be a felony. It's very serious. One of the other things, and I mentioned this earlier, is harboring an undocumented individual. If we intentionally, or an employer intentionally harbors away individuals during a raid, that's harboring, that's a felony. That's a federal felony. So, how would that happen? Well, let's say you've got a broom closet. And ICE comes in. Somebody opens the door. ICE comes into the factory. It's like, all right. The shop steward's like, all right, everybody in the broom closet. I'm going to lock the broom closet and everybody don't make a noise. And ICE goes through and they don't see anybody because all the folks went in the into the broom closet to hide. That's harboring. That's illegal. You can go to jail for that. We want our shop stewards to know, don't do that. Stand back, take notes, observe, do not interfere.
Are we breaking the law telling them, hey, if this goes down, this is what you need to do beforehand, not as it's going down, right?
That's a really good question. I think it is, if it's very specific instruction, okay, if ICE comes in, you are to go to door number 3 and lock the door, that's probably illegal. If you tell people, if ICE comes in, run like hell, that's okay, right? So the less specific you are in terms of advice on running like hell if ICE shows up, the better we are, frankly. All right. Any other questions? Sir?
In the training phase of this, if everyone knows that ICE is not allowed in the private or employee-only areas, then through common sense, hopefully people react the right way, and we don't have to direct or give any direction.
Hopefully. So that's part of the whole program, right? So, I mean, what we want to do is, hopefully we want to get to the employer before there's an ICE raid. So we want to bargain, we want to notice the employer and request bargaining with the employer over the effects of a potential ICE raid. A physical ICE raid, the facility, is going to have an immediate substantial impact on the terms and conditions of employment, both public sector and private sector. We have the right to bargain over the effects of what would happen if there's a raid. And so, again, we want to engage the employer before there's a raid, and the purpose of this really is to develop, hopefully, a cooperative plan with the employer on, number one, training employees on what to expect and what to do if there is ever a raid, and number two, what the employer's role is and what the employer is going to do in response to a raid. So, the plan would include such things as designating an employer contact in the event of a raid. So in other words, employees are not authorized to discuss anything with federal officers. The employees must know that there's a designated representative of the employer, and that's the person that they have to direct the ICE people to. Number two, and again, following that up, once that employer rep is designated, making sure that the employer is giving instructions to the employees that the employees are not to interact with federal officers, and only the designated employer representative is to interact with the feds. Super important. Number two, we want immediate notice of any raid. The employer can pick up the phone, can text us, send email, whatever it happens to be, WhatsApp, I don't care, but the union should receive immediate notice anytime the employer believes that there is a raid or a raid is actually happening. Number four, the signs that Claudia and Rosemarie had are super important. Let's make sure the employer is designating the non-public areas of the employer's facility. Why is that important? So, it's important because number one, you need a warrant. Got it. Once the employer posts an area of its facility as non-public, that area is private. There's a reasonable expectation of privacy within that area, and that means you've got to have one of those signed judicial warrants. And the warrant can be for two things. What can they be for? The whole property or a person. And so, if the warrant is for a person, and they're going into that non-public private area, again, there should be a plan that the ICE officer is escorted directly to the workstation where the person is who they have the warrant for, and they're escorted right out after they get that person. They don't deviate one step from that route. And last but not least, again, we beat this horse till it's a bloody pulp. Training employees on their rights, making sure they know what documentation they have. A lot of workplaces have lockers, right? Changing rooms. People tend to keep their stuff in their lockers. That might not be good enough anymore, man. I mean, if you're detained and you don't have, they're not giving you the right to go to your locker to get your personal effects, you're not going to have the documentation that you've now been keeping on you to show that you are actually a U.S. citizen or you have the right to be here. So we want to make sure, again, that people aren't lulled into a false sense of security, that they can put stuff in their lockers and they'll still be okay. It really should be on your person. We should encourage the employer to practice their plans, just like a fire drill, right? Just like we practice the whole fire drill. Do a practice of a raid. See how your workforce reacts. One of the things that we do have in 21st century America that we did not have before the turn of the century, or maybe just before, we got these. Camera phones. Right? Right. And guess what? If an ICE officer is standing on the street or in a public area, does that ICE officer have an expectation of privacy? No. They sure as shit don't. And guess what? What we have as citizens. We talked about the 4th, 5th, and 6th Amendment, but there's another amendment that allows us in an open area where nobody has an expectation of privacy to freaking record them. What amendment is that? The First Amendment. So the First Amendment gives us the right, if ICE is in an open area, to record them. And if they want to come and, like Claudia said, let's be uploading that stuff to the cloud as soon as possible, because we'll talk about that again in the next section. But to the extent that we can document inappropriate conduct by ICE, absolutely. We want to do that, no doubt. So in this area, when we're dealing with raids, we want to make sure that the employer understands and that they have a specific rule and they've trained their employees. Never, ever, ever allow a federal agent in a non-public area of the work site without either a proper warrant or permission from management. Never, ever, ever should a bargaining employee be placed in a position where they are deciding on whether or not to give permission to ICE to come into a facility. Absolutely not. That's got to be a management decision. So again, effects bargaining, we have the effects bargaining template that I put together for y'all. 4 areas of information here that are pretty important, I think. Number one, pretty obvious, if the employer has a current plan for responding to immigration raids, we want to see a copy of that. Sort of related to it, but not necessarily the same thing, how's about a copy of any of their emergency response and evacuation plans? Because that kind of is a sort of a structure on how we deal with things where people might want to run out of the building as quickly as possible, right? So evacuation, disaster plans, that might give us a good basis idea on how to propose to the employer another plan to deal with ICE raids. We want a diagram of the employer's facility, right? We want to know what this place looks like, where you can enter the facility, where you can exit the facility, things like that, where there are, say, man traps, where there are public doors, non-public doors. You want to identify all of those points of access and egress in the employer's facility as we're making these plans with the employer. Last but not least, if the employer is proactive and they have had communications with employees about their employees' rights, what to do under the circumstances, we want copies of those correspondence and any kind of those rules that the employer may have promulgated to their employees. And again, we want to talk to the employer about joining up with community organizations like Rose and Claudia's, really for the very important purpose of making sure that the families of the workers are supported. Because God forbid, if the worst case scenario occurs and a loved one at work is grabbed by ICE, family members are going to be freaking out. Right? I mean, look, if my wife is 10 minutes late from a shopping trip, I'm freaking out. I can't imagine the stress and the anxiety that family members go under and would incur if suddenly your father, your husband doesn't come home from work on a normal day. What the fuck? So we want to encourage employers to partner up with community organizations that are going to provide support for working families that have loved ones who are detained by ICE. And going further than just support, we would like to see employers maybe even donate some money to these organizations so that these organizations can, for instance, provide legal services for workers who can't afford to hire their own attorneys. I think that's something that's really, really important. All right. Any questions before we move on to the last thing? The raid has happened, and what do we do now? And this is sort of obviously the worst case scenario, the worst place to be, but there are things that we can do to try to make the situation better and to protect the rights of our members. So again, as we talked about ad nauseum, ICE has got to have the judicial warrant to get in to the work site. And again, that warrant must specify either the search is to take place at the entire facility or that they're looking for a specific individual. And if we are looking at a specific individual, ICE goes directly to that person, does not deviate from their path, and then gets the hell out of the place after they have found that person. One of the biggest things that we just sort of alluded to in the wake of a raid is detainment, finding out the names of people who have been detained, and the location where these individuals have gone. Well, number one, the names of the individuals are probably going to be within the knowledge and control of the employer. So we can definitely make an information request to the employer about who they know was detained by ICE, whether or not those individuals were released in to the employer's knowledge or continue to be detained. The employer will not necessarily have information about where the individual employee has been sent after they were detained. As Claudia and Rose noted, what we're seeing, unfortunately, are very, very quick moves of detainees to other states out of California, primarily mostly to Texas. Again, community organizations that have access to the databases or have the ability to educate family members on how to access the databases to find out where their loved ones are is going to be absolutely critical in the wake of and after a raid. Now, we talked very briefly when Rose and Claudia were here about bad behavior by feds can be a civil or can result in civil liability. Bad behavior by the feds could also potentially negate and allow a detainee to toss out their detention. So one of the other things we're going to be doing after a raid has occurred is we're going to be making information requests for every piece of information the employer has about the raid. Did any employer representatives take notes about interactions or conversations with ICE agents? If so, we want copies of that. Did the ICE agents leave any of their own statements behind? We want copies of those. And very importantly, the employer is going to normally have what all around its facilities? Cameras! Security cameras. We're entitled to get all of the analog or digital videos, pictures, and or audio that the employer captured on any of its security cameras. And by the way, if an employer agent captured any of that stuff on their cell phone for purposes of the employer's business, guess what? we get that too. So we want to be making information requests about all of this data that's going to help us determine whether or not there was bad behavior by the feds. If there is bad behavior, then we're most likely, hopefully, going to get that information to a civil rights attorney who hopefully can sue the crap out of the federal government, and if nothing else, at least get some nice money for the people who got badly treated by the federal government. We want to make sure that there's a network in place or a support system in place so that family members are able to determine the status of a detainee, where they are, and potentially how much time they have left in the United States. That's going to be very, very important in terms of making sure we've got counsel and representation for that individual before they're placed on a plane to Ghana. We've talked about this a lot also in terms of our effects bargaining. We can make advanced economic proposals, and somebody, I think from, was it 396, who had mentioned that they had already got language in one of their contracts that deal with this stuff. So again, paid leave while you're out trying to take care of your immigration status, continuation of health insurance, making sure that you can cash out your accrued vacation pay and that gets paid properly, all of those types of things. And again, your imagination is really the limit on what we could propose in terms of effects bargaining for this type of stuff. We talked about also final paychecks, vacation payouts, and that if those are not paid on time, there can be very substantial penalties for the employers under state of California law. So we want to obviously get together with the employer, make sure people are getting their correct payments timely, because that's probably going to be really instrumental and important in their ability to potentially retain an attorney and do other things necessary to help out in a very, very fraught time for that family. As we have also talked about, knowingly harboring, assisting the flight of an undocumented worker is a federal crime. And so therefore we cannot and should not ever advise our members to do that. We should not be doing that. If we do, I will disavow any knowledge of it because I told you not to do it. Last but not least, what are some of our proactive steps that we can take, especially with our members? Well, number one, when we do our training, the most important thing is never run and stay calm. Remember what Rose and Claudia said. And in the law, we call this furtive conduct. F-U-R-T-I-V-E, furtive. Criminals do furtive things, man. They're sneaky and furtive and stuff. So this is what we would call furtive conduct. And furtive conduct gives the police probable cause to stop you. If you're running away from a police officer, that's absolute proof that you are a bad person and you're doing something wrong. So unfortunately, running away from ICE gives them probable cause to come and tackle you, handcuff you, throw you in the back of the truck, and take you to Ghana. So don't run, don't panic. Know your rights. We also want to make sure that not only does the employer know about this distinction between public areas and private areas in the workplace, we damn sure want to make sure that our members know that. Because again, we don't want somebody in the bargaining unit who's behind a door that says no entrance, federal agents prohibited, private property, no entrance without a warrant. We don't want that person opening up the door and saying, oh, hey, come on in. We want to make sure that our people know those distinctions and that they fully understand that if they are in private property behind a closed door that says no entrance, no feds without a warrant, that they can keep that door closed and they do not have to open it without that warrant being slipped under the door. Finally, when members are detained, we want to make sure again that they understand their rights. You have the Fourth Amendment right to remain silent. Sixth Amendment right to consultation with an attorney. You do not have to turn over any documents unless the feds have a warrant for those documents from you. At the end of the day, there's a whole lot of stuff to unpack, to get ready for, and to do. And just to make sure, the last handout for the raid situation, also a bargaining demand and information request for that included with the materials. This is probably one of the most massive issues that we're going to have to deal with over the next 5 years. I think this is going to take everything that we've got to make sure that our people understand their rights, employers understand their rights, and that our bargaining unit members are protected to the full extent of the law. And in closing, I just want to say one thing. A person of a certain religion and a certain race, I'm pretty sensitive to these things. There was a saying when the Nazis took over Germany, and I think it fits here. And the saying was, first they came for the commies, took them away. Then they came for the socialists, they took them away. Then they came for the gays, they took them away. Then they came for the trade unionists, they took them away. Then they came for the liberals and the professors in academia, and they took them away, and I didn't say anything. And then they came for me, and nobody said anything for me. Well, folks, it's time to say something. It's time to stand up. It's time to say, we've had enough, because when we fight, we win! Thank you.